Appeals, Division 1 is now in session.
Please be seated. Court now calls case number CV1413, BMO versus Reed et al. This is the time set for oral argument. Counsel, let me advise you that this proceeding is being audio and video recorded, and a link to these proceedings will be on the court's website within a few days, so keep that in mind. Please identify yourself and your client when you get up to speak. I do have your sign-in sheet, and I'll try to make sure I call you by the right name that you have on this sheet. Each side has 20 minutes. Counsel for the appellant, you can set aside time for rebuttal. Keep in mind we've read the briefs, we've conferenced this case, we're very familiar with the facts and very familiar with the issues. You have a podium in front of you to keep track of time. And with that, counsel for the appellant, Mr. Armstrong?
Yes, Your Honor. Good morning, Your Honors. My name is Jim Armstrong. I'm with the law firm of Sachs Tierney. I'm here with the co-author of the brief, my partner Brian Ditch, and we represent the Reed appellants. This case presents an important choice of law question which is critical to the administration of Arizona probates involving out-of-state decedents with property in this state that is subject to the claims of local creditors. Art Reed is a Canadian citizen who died in Phoenix on January 1, 2009. At the time, he had an outstanding loan indebtedness owed to BMO Harris Bank, secured by a 16-acre parcel of real estate located in Cave Creek. The bank received written notification of Mr. Reed's death and the appointment of his wife as his personal representative in Canada no later than February 4, 2009. But the bank made no claim anywhere against Mr. Reed's estate until the filing of this lawsuit on October 28, 2011.
Did the estate or Mrs. Reed tell the bank they needed to file a claim?
They sent written notification, I think on 3 separate occasions.
What is Canada law? I know what Arizona law says. Arizona law says there needs to be a notice to creditors and a direct notice to known creditors as opposed to a publication. But if this is a choice of law question, what does Canadian law say?
Well, I don't know what Canadian law provides in that circumstance, Your Honor.
It's not a choice of law issue. It's whether or not they had complied with Arizona law.
We believe it is a choice of law issue because this case was brought in Arizona court,
okay,
involving Arizona real estate, and a claim against the probate estate of Mr. Reed, the debtor and the owner of the real estate, that under those circumstances, including the statutes we cited from Arizona, as well as the restatement of conflicts, Professor Schoenblum's treatise, the authorities are unanimous that in that circumstance, the local probate procedures govern the processing of the claim, including all of the time limits involved, most specifically in this case, the 2-year non-claim statute in section 14-3803.
Isn't the problem with the non-claim statute that you've got to have notice of that you need to file a claim, and that would be under the local law with respect to notice?
In fact, that is not true, Your Honor. There is an opportunity to give notice. I believe that may shorten the period, but if no notice is given, there's still an absolute 2-year claim bar. And again, that ignores the fact that there was, in fact, notice given 3 times in January and February, immediately following Mr. Reed's death, not only notifying the bank of his death, but also notifying that Mrs. Reed had been appointed as a personal representative of his estate in Canada. So they clearly had notice. They acknowledged receipt of that notice in February 4. So that's, one of the undisputed facts here that I think the trial court ignored. The trial court ruled as a matter of law that because there was a primary probate proceeding in Canada, that Arizona law just simply did not apply. The law on the...
Could Arizona law being invoked by doing more than filing the proof of authority when it was in, I think, February 2010?
I'm not sure I understand your question, Your Honor.
Okay. Could Mrs. Reed, as the appointed personal representative, when she filed the proof of authority, then file the notice to creditors under Arizona law?
I don't believe that statute is interrelated. The proof of authority statute is interrelated with the notice to creditors requirement. The proof of authority simply allows her to collect assets on behalf of the estate for the primary probate. It does nothing further than that.
But she could have brought an ancillary action in Arizona.
She could have.
Okay.
And in fact, the bank could have requested that she do so. And if she didn't do so, the bank itself, as a creditor, had standing under the priority statute to commence a local probate, either an informal or a formal probate, and ask that itself be appointed as the personal representative. And that's the major point of our brief, Your Honor, is that they didn't do so. The bank had several options. First of which, they could have filed a claim in Canada. Again, they received notice almost immediately after his death. They didn't do that. They could have requested Mrs. Reed to open an ancillary probate in Arizona. They didn't do that. And thirdly, as I just mentioned, they could have opened a local probate themselves. Instead, they sat on their hands for 2 years and 10 months before commencing this lawsuit.
But if the estate had stopped paying, they may have been forced to do something, but they continue to get paid.
That brings us to another argument they've made, and that is they argue that a different provision of the non-claim statute should apply for debts arising after the death of the decedent. They claim that this case falls within that circumstances because payments were continuing to be made under the deed of trust. Actually past even the 2-year point of the non-claim statute. The statutes, the subsection A of the non-claim statute, however, defining claims arising before death, include claims that are due or not due, contingent or unliquidated claims.
That's in 3810, yeah.
Yes. This claim, clearly that. We've also cited case law from Washington. There's a string of Washington decisions interpreting statutes with that identical language, due or not yet due, liquidated, contingent, unliquidated or contingent, that hold that the debt arises when the contract is signed, when the decedent enters into the agreement requiring long-term payments. In those cases, it was leases. It was also mortgage payments. In all of those cases, payments did continue to be made following the death of the decedent, but the court in all of those cases held that the claims were barred. They should have been brought, even though there was no default, they should have been brought within the period of the non-claim statute. I want to point out also, Your Honor, there's another Arizona statute, section 143810, which deals with what do you do when you have a claim that's not due, that's contingent. And one of the options is to ask the court for a hearing to determine, for example, the present value of the stream of payments. So there is a process in place in Arizona to handle precisely this type of claim, and again, the bank failed to take advantage of that process.
And all they needed to do was to send to Mrs. Reed, saying that the value or the payments left on the note are whatever they might have been at the time.
Correct, and then again, there could have been a hearing to determine present value. There could have been a negotiation on a sale of the property at a much earlier point when it had much greater value than it had at the time of the foreclosure sale. So again, another reason, the overarching purpose of the probate statutes are to provide for an efficient, orderly way of paying people, paying beneficiaries and claimants. That's why there are these time limits, and in this case, it's a perfect example of why those time limits are a good thing, because at the time, the Arizona real estate market was in free fall, and this property was declining, at an unbelievably rapid rate. So again, prompting what that shows is that early action would have been better and was required rather than waiting as long as the bank did.
Mr. Reed bought when it was high and unfortunately passed away as it was in free fall.
That's true, and never got the chance to build the residence that he wanted for he and his wife. And again, the bank was notified of that. There was a letter sent to them along the way from Mr. Reed's business associates explaining the circumstances. We've put this much money into the property. We can't continue to maintain it. Would you allow a short sale? So it was clear the bank, knew the fact that this property was in financial distress as well. Let's go. Let's return to the local ancillary question, because I know the bank raises this quite frequently. They cite another statute, 144207, which states that Chapter 3 of the Probate Code, which includes the non-claim statute, governs the appointment of local personal representatives and the rights of claimants with regard to a local administration. The bank then says, well, there was no local administration, therefore Chapter 3 doesn't apply. Well, that's a bit of false logic. First of all, Section 144207 doesn't preclude the application of Chapter 3 to other claims or other circumstances. And more importantly, their argument begs the question. Again, the point of our brief, not only on appeal but in the trial court, was the bank had the right, if not the obligation, if they wanted to protect themselves, is to open a local ancillary proceeding. And again, they didn't do that.
It seems that at least in the structure of the probate code, secured creditors are protected under the Arizona version as well as the UPC.
Yes, that's Section 143104. That's one of the jurisdictional statutes, one of the statutes that says Arizona law applies to all proceedings and actions to enforce a claim against the estate are governed by the procedures of Chapter 3. It creates an exemption, however, for trustee sales. So if the bank simply wanted to do a trustee sale and nothing else, they could do that outside the probate proceeding. However, that same exemption says it does not apply to deficiency claims. And in fact, that's what we have here, a deficiency claim, or at least an alleged deficiency claim. And therefore, the probate code, including Chapter 3, did apply to the remainder of their claim after the foreclosure took place. The last argument that the bank makes is that it did, in fact, present its claim in a timely fashion because there were loan statements, monthly loan statements that were being mailed to Mr.
Are those in the record?
Yes, some of them. They are in the record. We actually placed them in the record. This came up in the final oral argument before the trial court, when I think the judge asked, well, were there monthly loan payments? And I think counsel for the bank said, yes, there were, but there was nothing in front of the court at that time. That's why we filed a second new trial motion to get those in the record and to explain why they didn't qualify as a proper presentment of the claim.
They weren't in at the time of the oral argument?
At the time of the, I think, the second
oral argument. But you placed them into the record
in the final oral. There were actually, I think, 3 oral arguments, and this was in the oral argument at the third one.
I was just thinking about the summary judgment oral argument,
right,
where the court made the.
I think that was a new trial motion at the time. Those statements do not qualify. First, for one, a very important reason. In order to present a claim, there's got to be a personal representative and an administration open. There wasn't in Arizona. Again, it was never done. There was never a local proceeding commenced.
But if it was sent to Mrs. Reed or a representative in Canada, wouldn't it apply?
I guess that depends on Canadian law. I think if
you start out by saying they could have filed something with Emily or something in Canada.
They could have.
And if they in fact did, why wouldn't this work without having to open a local administration or do an ancillary in Arizona?
Well, again, Canadian law, I'm not a Canadian lawyer. I don't know the intricacies of Canadian probate procedure. My point is that if they had gone to Canada, perhaps those loan statements would have been adequate notice. Under Arizona law, again, there was no personal representative, no administration that had been open, but even if there had been, those statements don't qualify as proper presentment because they were sent to the wrong person. First of all, they were sent to a deceased individual, and not even at his place of residence. They were sent to his business address. And it's clear, these statutes are strictly construed. And consequently, there's case law, I think it's the Berry case that we cited, where the person represented and her lawyer were given oral notice of the claim and shown documentation of it, and the court said, nope, that's not enough.
You said oral notice wasn't enough.
Well, but part of the facts were they were also shown documentation of the claim, and they were given an opportunity to copy it. So that's pretty close to the line. and the court held no, that wasn't sufficient. So I think that disposes of that argument.
Counsel, before you keep going, I'm still tangling with your argument that a creditor is required to bring a claim even where there's been no breach.
Correct.
And is there an Arizona case that supports that?
The closest is probably, there's none that's directly on point, Your Honor. What we're relying on is the precise language of the statute, which again uses the terms claims that are due or not yet due, contingent or unliquidated. And that same language has been interpreted by the state courts of Washington on numerous occasions to cover precisely this type of situation.
So the claim would be we want the estate to acknowledge the agreement or something?
Yes, the claim is we have this contractual obligation. There's a stream of payments that's due. The claim would then go through the process of being allowed or disallowed by the public, by the personal representative. If it's allowed, then there's this procedure under that 143810 for how do you deal with a claim that's not yet mature. And one way of doing that, again, is to hold a hearing to determine the present value of the payments.
A claim that's not yet mature would include a claim that doesn't even exist? That is, I mean, you can't go to court on a debt that's being paid currently, right?
Well, a claim for purposes of that statute is more broadly defined, I believe, than what we normally think of as a claim. And it's a contractual obligation. A contractual obligation is an obligation that is equated with a claim under this statute. And it has to be dealt with in probate administration.
I guess there would be like some kind of an analogy to bankruptcy where a debt will be expunged if the creditor does not come in and take steps to either show that it should persist or that it should be paid out of the estate.
Well, I'm glad you made that analogy, Your Honor, because it is exactly like the claim procedure in bankruptcy, and there's a reason for that. And I see my time's getting short. Let me end on this. The whole process, the whole scheme of probate law is to provide a window for claimants and beneficiaries to make their claims, particularly in the case where there's an estate underwater, like a bankruptcy situation. If you don't get your claim in, there's pro rata distributions, there's priority payments according to the level of the creditor or the beneficiary. They're all paid. If you allow someone to come in after all of that has happened, you've undermined the finality of the proceeding, and you've created this massive disruption about how then do you get money back from people that have already been paid. So again, that's just underlies the importance of the probate scheme and why the time limits should be followed.
There at least presumably could be defenses like latches and some equitable defense.
Well, we have a better defense here, and that's the non-claim statute. Unless Your Honors have any other questions, I'd like to reserve the rest of my time.
Thank you, counsel. Mr. Begley?
Good morning, Judge Portley, Judge Gould, Judge Thompson. My name is William Begley with the Kavanaugh Law Firm. I am here on behalf of BMO Harris Bank, who is legal successor to M&I Marshall and Ilsley Bank. Also with me is attorney Philip Mitchell, who had extensive involvement in this file.
Mr. Begley, what about this assertion that a claim includes a debt that's not in default and currently and is current?
Your Honor, we obviously disagree with that entirely.
Well, the assertion is that there's a bunch of Washington cases that, presumably interpreting a similar provision, support that.
And, Your Honor, I think they are very distinguishable because obviously we're not in Washington, and they have talked about their interpretation of the statute that's at work here. If Your Honors review that statute in terms of the definition of the word claim or claims, the word that jumps out at you is liabilities. And that's exactly what Judge Thompson is saying. Until there's a default.
Which statute has the definition?
I'm sorry, Your Honor, I don't have it right at hand.
Because I am looking at 14-3803A. I mean, it's got all this broad language, all claims whether due or to become due, absolute or contingent, liquidated or unliquidated, founded on contract, tort, or other legal basis, etc. I mean, that presumes it's a claim, I guess, whether it is modified by all those adjectives.
Well, as Your Honor was saying, though, as we explained in the brief, and I apologize not having the statute right at hand, but as we explained in the brief, the bank...
Usually at the beginning. I'll look at the beginning.
the bank has no right of action until there's a default. And as Judge Portley pointed out, under the promissory note, which is what we sued on, a breach of contract, until there has been a default, which is defined as a failure to make the monthly payment, the bank has no opportunity to come forward and institute any action against Arthur Reed, living or deceased.
Well, but couldn't the bank just filed with Mrs. Reed a notice that, we're sorry for your loss, your husband still owes us $1.5 million on the note, you're still making payments, but we want to make sure that we get in?
Your Honor, the
whatever
reason
that might be, or whatever that might mean.
Your Honor, the reason we believe we accomplished that is, number one, the estate never sent any notice of bar date to the bank about bringing a claim. Number two, and perhaps more importantly, the bank continued to send its monthly invoice, its monthly statement. So every time for the 2 years and 7 months from the date of Mr. Reed's death until the default, 2 years and 7 months, they were receiving notice and they were using an auto pay account to issue payments to the bank. Again, no default. So they were well aware of this debt. Mr. Reed had borrowed $2.5 million. He still owed over $1 million. That's why the action that was brought is a case under Title 33, not a case under Title 14. Once the bank achieves its right to collect under Title 33, then the bank is going to take that judgment, Your Honors, and head to Canada and whatever is necessary to reopen the estate and enforce it. And that has already begun. Actions are proceeding in Canada in that regard. That's why we believe the mislead here is to thrust Title 14 in the direction of Title 33. Everything was done appropriately under Title 33. There were no exceptions to that made by the other side. And indeed, in terms of the amount of the deficiency...
Talking about the trustee statutes now, right?
Yes, Your Honor. And indeed, in terms of the amount of debt remaining, the fair market value of the collateral that we sold because of the deed of trust that was given to us, those were all stipulated to by the other side.
Well, so you're saying this is go on, John.
Well, it strikes me as an odd arrangement if, in the first place, the debt isn't even in default. After it is in default, if you invoke the trustee sale, the power of sale, you don't even know how much the claim is because you don't know how much you're going to get from the trustee sale.
Exactly, Your Honor.
So I'm not exactly sure. I guess the estate, under the appellant's theory, the estate would just stay open until everything gets the trustee sale happens, and if there's a foreclosure or a deficiency action, all that occurs.
Well, Your Honor, returning to the statute that
Certainly can't send them a claim that says you owe us X dollars.
That's right.
Yeah.
How do we come up with that number? By sending them a monthly invoice of this month you owe us this amount of money, we are giving them notice for over 2 years, 2.5 years, which they complied with, during which time they conducted their probate in Canada and closed it.
I mean, I guess if it were a bankruptcy, the bankruptcy case would just stay open until everything was adjudicated, if that's the analogy.
And as I mentioned to Your Honors, that's why we believe step 2 in our process, unrelated to any of the issues before this court, will be to head up to Canada and go on to that probate matter.
How do you get around the last sentence in 3104 that seems to suggest you're free to do whatever you want with respect to enforcing your rights under the security, except as to any deficiency judgment which could be sought.
Your Honor,
It seems to try to take a Title 33 action and say, you got to do something. You got to put people on some notice.
which we
And
did.
your position is, as I'm thinking out loud, we didn't get a notice of claim, so we didn't have to file anything.
We were simply told Mr. Reed had passed away. And as a bank, if we receive a payment for the invoice we've sent out, we must accept that payment. We can't send it
I'm
back
not
to them.
saying you're going to return the payment. No bank's ever going to give money back that someone owes, you know. We're sorry for your loss. Here's your check back. I don't think so.
And Your Honor, I guess maybe another point I want to make, because I know time flies here during the 20 minutes, but we have Section 14.
It's fine.
We have Section 143803A, which the other side would like to use as a bar to our action, basically a statute of limitations. But as we point out in the brief, if Title 14 has applicability to these facts and circumstances, you have to look at 14-3803C, which talks about claims arising after the death. And as we pointed out, our claim did not arise until the default more than 2.5 years after the death.
And although the claims after death would certainly include like funeral expenses and things like that, the appellants are saying your claim against the estate preceded death.
Well, they're saying that once
Showed
we,
you the money.
what they're saying, which we totally reject, is that once he incurred debt, we had a claim. But that gets back to what I think Your Honor was talking about.
I did find the definition of claims, by the way. It's in 14-1201-6, and it's an inclusive definition, which seems to just say, well, it includes debts that arose both before and after death.
And I think that gets back to what Your Honor was talking to me about at the beginning, and that is, once I say we have a claim because he incurred a debt, and then the judge says to us, how much is your claim?
Yeah, the definition refers to, it basically describes claims in terms of liabilities. And so that is something of an ambiguous term in this context. Does a liability mean something presently that somebody could sue on, or does it mean a liability is a debt that somebody owes to somebody?
And in that regard, before I go much further, let me thank Your Honor for finding the statute that I failed to write down here in my notes. Thank you.
Like I said, I looked at the beginning of the book. That's usually the place to find definitions.
I think I should have brought the book. Again, under 3803C, all I would add is that you have a 4-month period within which to file your action, which we accomplished. The default was in August of 2011. We had filed our Title 33 action by October of 2011. So,
And that's assuming that the regular mortgage statements met the notice provision.
well, and the action we filed was the actual complaint in Superior Court, which led to the cross motions for summary judgment.
Well, but the 4-month provision only applies if there's notice to creditors by publication. So you would get 2 years and 4 months to file your claim or file your lawsuit. And so we wrestle with what Judge Thompson has raised and what the Reed estate thinks is clear is, when's the claim? You think it's when they default. They say it's an ongoing that was incurred prior to January 1st of 2009.
And, Your Honor, as we've said, we believe the notice is out there every month, like clockwork, in the form of the invoice coming from the bank, as well as the fact that this estate was not administered by an unsophisticated person. As we pointed out, and there are declarations submitted to the trial court, the son-in-law is an attorney.
Why does that matter?
Simply because we know he received the notice because he was making the payments. He, as a business associate of Mr. Reed. This is a highly solvent estate.
Someone dies, and, you know, the electric company sends a bill, and, you know, the surviving child, you know, comes there, sees it, I got to pay the bill, and pays it. But doesn't know that, you know, there's also, you know, the cost for the solar expense that mom just put up on there. So why does the sophistication matter if a creditor has to give notice?
I guess all I'm saying to Your Honor is that what an attorney who is also representing the estate in the probate in Canada receives and reads, he may have a greater appreciation of what it is and means than maybe a little person who maintains a house with a couple of lights on. That's all, Your Honor. The other reason that we believe the claim simply doesn't arise until the default is the default gives the bank the right to accelerate the entire amount due. And that's what we pled for in October when we filed our complaint. Those are the rights. We pointed to a lot of the language in the note that talks about if anyone assumes the obligations under the note, they have to comply by the terms of the note. And we would argue that the sophisticated attorney assumed those obligations in making sure the auto pay was funded.
Did you find any cases in looking at the Uniform Probate Code, you know, maybe cases along our northern border where this may have popped up his head earlier? I didn't see anything in Washington or Minnesota or the Dakotas that would help guide us, but
We did not, Your Honor, but we were advised of a couple of relevant sections of the Alberta Edmonton Canada Code, which we cited in our brief in terms of the aspect of the claim and the right to follow the claim even to the party who receives the inheritance. And here, the personal representative, Mrs. Reed, is a 100% beneficiary of this estate.
based on the will.
There is a second issue raised by the other side in here in terms of the applicability of Section 33-814 and the Colhase case that this court decided. I think the briefs are very thorough in terms of explaining how this case is on point with Colhase, which got its lead from an Arizona District Court case, RTC versus Freeway Land Investors, in which once you file the action before the trustee's sale, and then later you conduct the trustee's sale, you don't have to file a whole new complaint or amend your complaint to start using language that explains all that, because the statute talks about you must maintain a lawsuit within 90 days of the trustee's sale. And in Colhase, this court interpreted that word maintain in interpreting the statute as including a lawsuit that was filed before and continues preservation of that right.
We wrote an opinion that basically characterized an action, basically a foreclosure action, as an action on the debt. If you sell the property under the power of sale in the meantime, it's sort of analogous to prejudgment, attachment, or execution. It's still an action on the debt when there's money left over. So I don't think that the action for the deficiency is a separate action from the original action on the obligation.
That's right, Your Honor. We're simply walking through the steps of Title 33, exercising the rights we have under all of the documents executed by Mr. Reed.
The money you get from the trustee sale just reduces the indebtedness.
Exactly. And in this case, the parties even later stipulated to a fair market value for this property. And provided that evidence to the trial court, who accepted it.
Now, there is an interesting statute here, 14-3810. I don't know if anybody talked about this.
3810?
Yes.
Where a personal representative or someone can continue to pay as long as it's in the best interest of the estate?
It's basically, that's one aspect of it. It's basically how to deal with claims which are contingent or unliquidated. But that doesn't really answer a question. But it basically has it says if a claim which will become due at a future time or a contingent or unliquidated claim becomes due or certain before the distribution of the estate, and if the claim has been allowed, et cetera, then you pay it out of the estate. Then in other cases where it hasn't, the claim has not been liquidated or determined, you can reach an agreement as to its present value or make an arrangement for future payment with a bond or something like that. It's question begging to the extent that we still have to figure out whether it's a claim and if it's not in default.
Well, and Your Honors, I believe another critical point is there's been discussion of the ancillary probate proceeding, the local administration. There was no local administration filed in this case. Everyone agrees with that. Mrs. Reed, whenever she appeared in this case with her proof of authority, was as a foreign personal representative. And we pointed out how you can't have both. You're either a foreign personal representative or you're a local personal representative. In addition, as the trial court noted,
standing to participate in your action, correct?
As her proof of authority, she has identified herself as the personal representative of the estate that's being probated in Canada. And we think that's a critical point that gets lost sometimes. The probate domiciliary was filed in Canada and closed so far in Canada. It's not that there was no probate out there and therefore the bank has some duty to seek an appointment of a local personal representative in order to maintain its action. There was a personal representative in place, foreign, who filed a proof of authority, which simply gives her the right to transfer assets that are here in the state. All of the statutes say that's the authority that she receives. She never came forward in any point, and when it was suggested to the trial court, well, why don't you go be a personal representative too, bank, by the other side? They said, no, there's already a personal representative that's been named in this case, and that's Mrs. Reed in Canada. The bank can't simply initiate its own action in Arizona and say, well, we'd like to make our VP the personal representative here in Arizona.
Can I be clear about what your assertion is about this 2-year provision? Your assertion is that this provision in Title 14 is not a defense to your action.
Correct, Your Honor.
Because your action is a Title 33 action in Arizona. Whatever's going on in Canada with the state has nothing to do with your action.
That's correct.
So, I mean, if that were right, then it wouldn't matter what this stuff says or means, what Title 14 says or means.
And that's why our first argument is Title 14 doesn't apply to this case. It's irrelevant. We believe that's what the trial court said in its minute entry ruling on the cross motions for summary judgment. We made an alternative argument out of safety and caution that even if this court concludes Title 14 has some relevance, the subsection C says you have to file your action within 4 months, and we did.
Thank you, counsel.
Thank you.
Counsel?
Yes, Your Honor. First, on the last point Mr. Begley just made, I think Your Honor correctly pointed out that Title 14 is thrust into this case, to use counsel's term, by Section 143104, which says that Chapter 3 of the Code applies to claims and then creates the exemption for trustee sales, but specifically denounces that exemption for deficiency actions. This is a deficiency action, therefore Title 14 does apply. The next to last point made by Mr. Begley and they argued this in their briefs, and the trial court also made this erroneous conclusion, that you can't have both a foreign primary probate with a personal representative in place and an ancillary probate in Arizona, and with a different personal representative or the same probate personal representative. Absolutely not true. First, the Canadian probate was closed in September 2010. There was still over 3 months left under the 2-year non-claim period where the bank could have come in and commenced a local administration. Secondly, there is a statutory bar to open informal probate proceedings if there is a foreign primary probate already in place. That bar does not apply, however, to formal probate proceedings. So the bank had two options. Even before the estate was closed, they could have opened a formal probate proceeding in Arizona. After the probate was closed, they could have opened either an informal or a formal probate proceeding. Your Honor, Judge Portley, you asked whether there was some case somewhere, maybe in the northern states. The closest,
Minnesota, anything along the Canadian
well, how
border.
about an Arizona case? We cited Flath v. Neal. Flath v. Neal involved an Alberta primary probate proceeding, a local probate proceeding opened in Mojave County, and the court held that it had jurisdiction because there were assets of the decedent in Mojave County. So there's an Arizona case.
It was ranch land and
Right.
grazing rights.
But is Mojave County really part of Arizona?
Last time I looked, yes. And I think part of, again, we talked about Section 1438.10. I brought that up before. I think that kind of resolves, I understand the confusion perhaps, or the uncertainty of what happens when you have a claim that's not yet due. That statute provides what exactly you do. You can agree to a payment stream. You can agree to present value. You can determine what to do with the claim. And that's what is required. That doesn't make the claim something that arises after death, which is subsection C of the statute, and I think, as one of your honors also pointed out, that applies to funeral expenses. That applies to the costs of administration. And it makes sense. There's a 4-month window to assert those claims, because those claims can actually come up after the 2 years of the non-claim statute. Probates go longer than 2 years. If you have a claim for an administrative expense, you can't, subsection C ensures that you're not barred. It gives you 4 months to file that claim. That's what that statute's about, not the claim that we have here. Thank you, Your Honor.
Thank you, counsel. We will take this matter under advisement and issue a written decision in due course. Court's in recess.